supported decision. It is a way to help people make their own decisions with the assistance of others. It's a process that involves a person with a disability or other needs getting support from trusted individuals like family members, their friends, or other professionals, where they can understand the information being presented to them at their level of understanding, be able to weigh those options, and then make informed decisions. So when you're making your own choices, we all do that on a regular basis in our lives. And a lot of times we all need help with that. And we kind of take that for granted. But supported decision making is able to put that into a more formal process of when you're receiving that assistance. So you choose people you trust to help you understand the information and consider those options. And as the person being supported, you get to stay in control of your life and your decisions, even though you have that support from those around you. You're able to have a better understanding of all of the different options that are available to you. And in some ways, I feel like it's a more informed opportunity for those choices because you're receiving that information from trusted resources. And then the most important part, it's respecting your rights. So you get to maintain your rights as an individual that we all have and be able to still make those choices about your life. So, in short, supported decision making is like having a team to help you make those informed decisions, but you are the one who ultimately decides at the end which route you want to take in that decision making. As far as control, when we talk about the difference between guardianship and supported decision making, you stay in control of your own decisions, like we've talked about. And then with guardianship, someone else is actually making those decisions for you and is the ultimate decider. The difference with independence is you're going to be getting help with the decisions, but you remain independent and make those final choices. With guardianship, you have the guardian has the legal authority to make those decisions on your behalf. While they should have your input when they're making those decisions, they are the ultimate decision maker. As far as choice of support, with supported decision making, you choose who helps you, and you can change your supporters at any time if you want without having to have any sort of intervention from any court. With guardianship, the court would appoint a guardian, and then it's very difficult to change who that person is going forward. So supported decision making offers a lot of flexibility. You're able to change those agreements that you make with individuals at any time for any reason. With guardianship, it's a more fixed arrangement where the guardian has ongoing control. Supported decision making respects your right to make your own decision and support your independence. Guardianship often removes or limits your ability to make decisions for yourself. So, supported decision making helps you make your own choices with support, while guardianship gives someone else the power to make decisions for you. We understand that supported decision making is not right for everyone. It does require the individual being supported to have the capacity to make decisions while also being able to learn from mistakes and be able to have that input. And is a place and time for guardianship. So one of the things that we wanted to do today is we wanted to take an opportunity to introduce a family that has experienced what it is to go through the guardianship process. And so at this time, I would like to introduce Beth Papp, who is a self-advocate, and Becky King, who is a parent and advocate.
Hello, I am Becky. So Beth had to step away, and I'm just going to go ahead and read her introduction for the moment until we get her back. Beth is a 23-year-old non-speaking person with an autism diagnosis. She did not have a reliable mode of communication until 2022 and has been advocating for herself and other non-speaking persons ever since. Like many other young adults with autism diagnoses in Arizona, Beth was placed under a full guardianship when she turned 18 years old. Beth advocates for herself and her peers to be allowed to exercise their basic human rights, most of which are legally taken away under guardianship. She is dedicated to bringing attention to these issues until all persons with disabilities can exercise their full rights. Um, and I am Becky. I am her mom. I'll go ahead and read some of my bio. I am also a disability rights advocate, thanks to my daughter, because I'm a mother to a young adult with disabilities. I have about 30 years of volunteer experience within the disability rights community, as well as some other parts of women's rights and technology and arts organizations. I've co-founded the Rights for Non-Speakers with my daughter. It's an Arizona not-for-profit, and we are working to empower, educate, and support non-speaking individuals and their allies. And it's been really important to us to participate in educating people about guardianship and supported decision making, because when Beth turned 18 and the time leading up to that, we really weren't aware of any other options. And now that there are more formal options, I think it's really important that people be educated before they make a decision about something that is really meant to be permanent, and make sure that it is the right choice for them. So there's quite a few questions that both Beth and I get when we talk to people about supported decision making. And one of the first ones is always really interesting. It's people asking, how do we know this is really the right option for us? Because especially from our experience in the state of Arizona, there's just this assumption for many years that once she turned 18, we would go to court and get a guardianship for her. And it just never, no one ever spoke to us about any other option. So people are wondering why, why would we choose something else? And what Beth usually encourages people to do is talk to your child, which doesn't always necessarily occur. A lot of times children, the individuals turning 18 aren't really involved in these conversations that are going on in school or IEP meetings or doctor's offices. So we strongly encourage people to have that conversation with your young person in whatever way makes the most sense for that. And that actually kind of goes with the last question. This is something I hear from a lot of parents as well, is like, well, I already make all their decisions. Like, why would we want to make it more complicated? And from a personal standpoint, until Beth had the option to start to exercise her decision-making kind of muscle, we didn't know what she could do, right? So I feel like going into a guardianship when she was 18 and not even giving her the opportunity to try to make those decisions was definitely shortchanging her ability to affect the direction of her life. So there is that sense of, is it simpler in many ways? That's very possible. Is it a better choice for some people that there is a formal guardianship in place that supported decision making? Absolutely. There are lots of families where I think that guardianship is probably most appropriate. But before that decision is made, we really encourage the people that we talk to have that conversation with their child and their support system to see if there is some room to help them exercise that choice over the decisions that are being made, decisions that need to be made in their life. I'll go back up to the second one. Our lawyer, doctor, teacher says guardianship is best, and are they right? That's something we personally experienced as a family. Was all the people said guardianship was the best option. That is partially because supported decision making wasn't around when she was 18, but even so, there are other ways to support our young people when they turn 18 other than guardianship. And knowing that a lot of individuals aren't necessarily in our support kind of ecosystem, are not necessarily educated about those options or very unsure of them, so don't want to speak to something that they're unsure of. I think it's really important that as individual families and individuals about to turn 18, that we encourage everyone to explore all the options, ask all the questions, which brings me to the one about what if there is an emergency. That was really kind of the one that got me as a mom was, oh my gosh, like, what does that mean when she turns 18? If there's like a medical emergency and I don't have this piece of paper in place, what's going to happen? And there was this big unknown, and there was a ton of fear around that. But what I didn't know at the time was that it's not any different than when my other children turn 18 and there's a medical emergency. I mean, that's a really good question and something that you should talk to your like medical professionals about or a lawyer about. But just because my daughter was under an IEP or has, a diagnosis, doesn't mean that a full guardianship is the answer to how to handle a medical emergency once she technically becomes an adult. And so I didn't even think to really push that question, to explore those options when she turned 18. And now we think it's really important to find a way to address things like that and potential emergencies and like urgent issues while still giving her autonomy over her life in general. Um, yeah, so those are just some of the things that we end up talking about on a regular basis.
Thank you, Becky. We really appreciate that parent perspective and the experience that your family has gone through. I really wish that supported decision making had been passed years ago when we first started advocating for that to happen. But we're seeing more and more states that are adopting this law, and it's just creating more options for families without having to actually go through the legal system. And so, one of the things that we wanted to do today is we wanted to go through like a sample scenario of what creating a supported decision making agreement looks like. And so, the first part of creating a supported decision making agreement is really that planning phase. Once you've determined that this is something that you want to try to either help support yourself or support somebody with a disability, we really recommend that you use a chart similar to this to identify who those potential supporters could be and the different areas of support, and then really kind of nail down how specifically you're wanting to be supported. So today, we're going to go through kind of a sample scenario here. Becky's going to help me, and she's going to play the part of mom. And the area of support that she's going to be providing is in medical, and specifically attending doctor's appointments. So being able to receive that information in that doctor's appointment, because we hear that a lot from families, is when they go to different appointments or they're at the emergency room, the question comes up, well, can I share this information with this person that's next to an individual with a disability? And so having this form
We have
with
a question
you
real quick.
is the thing that gives you that permission. So you're going to stop my screen share real quick, and I have a lot of things on my screen, so bear with me just for a moment.
Hey, Melanie, we have a question real quick while you're doing
Oh,
that.
sure, go ahead.
It says, well, what if your adult child cannot make that decision with the parent? So, um,
Yeah.
It's-
So that's where that capacity portion comes in. So it's really important that your child has the ability to make decisions. And that's something that the team would have to kind of navigate through. We always caution everyone that just because somebody might not have the capacity to make decisions at age 18 doesn't mean that they won't develop that ability to make decisions, especially if it really hasn't been something that's been navigated through. And so, Becky, you can kind of talk a little bit more about your experience specifically on not having that communication device.
Yeah, that's really the crux of the issue for us. When she turned 18, Beth didn't have effective communication. And so while we didn't have any indication that she could make decisions, um, that was because she literally didn't have a way to communicate that to us. And so when we went into a full guardianship, there is kind of this assumption baked in that this person will never be, they will be at the place that they are now perpetually. And maybe that's not an explicit assumption, but it did not leave room for the fact that she could continue to grow and develop as a person who could make her own decisions. And so that's the part that is challenging for us, because now that she can communicate and now that it's clear that she does have the capacity and has some strong desires to have control over her life, we are in, she's in a guardianship that is not meant to accommodate those things. It is not meant to be necessarily undone. So while I'm sure it's appropriate for lots of individuals to be in that full guardianship situation, I would hope that there could be some kind of in between for people to allow their young person to continue to evolve and grow as a person. And so those options can be very individualized, from supported decision making to little things all the way in between to like partial type guardianships and things I can't speak to, like, technically. But from our perspective, we're now in something that's meant to be permanent that is no longer appropriate because things have changed.
Yeah, and some of the things that are at stake that people don't think about when their child turns 18, and I've experienced this with supporting families, is that full guardianship can lead to, the removal of the rights to vote, the right to drive. And so, like Becky had said, undoing those guardianships can be very difficult when it's realized that the person that is under guardianship has the ability to exercise some of those rights, but now they are limited by that guardianship. And so we always advocate for, let's start with something less restrictive. And then if you need to move to more restrictive supports, then that's something that you can say, you've done your due diligence to provide those less restrictive options first. So can everyone on the screen see the Arizona Revised Statute? Yeah, like a head nod. Yep, Becky. Okay, perfect. Okay,
I
so
do have another question here. Sorry, there's a couple that come up. One of the parents that I work with received a supported decision-making agreement packet documents that asks for a signature from a lawyer. Is this necessary or required?
ask for a signature from a lawyer.
I don't know why, yeah.
No. So we'll go into how you will finalize the agreement. It does not require an attorney. You can always have an attorney review it if you feel like you need that, but it does not require it.
Yeah.
Any more questions? Okay, perfect. All right. So here is a blank supported decision-making agreement. Now, with this law only coming into fruition here in Arizona last year, we understand that right now we're in the educational process of trying to educate all of our medical providers, schools, anyone who could be involved in a person's life with a disability. And so we have provided a blank form at arcarizona.org. We have a tab called 18 and IDD, now what? And under that, it has a lot of different future planning tools, and this is one of them. So we included the actual statute at the beginning of the form, because then when you present this form to someone, it gives them the opportunity to educate themselves and familiarize themselves with the statute if they're not aware of it when you present it to them. So this first section here is just going to be going over the actual statute. And I won't bore you with all the legalese. And then you're going to get into the meat and bones of an agreement. And so this is where I'm going to have Becky help me because we are going to fill one out today.
Sorry, we do another question before we go by. It says, "Whoa, DDD recognize supporting decision making. Our son's DDD's caseworker is insisting that all emails and requests that come from our son, who is not under guardianship. My son has autism, and although is highly functioning, cannot follow through with requests."
Yes. So everyone in the state of Arizona is legally obligated to recognize this form when you present it to them, including DDD support coordinators. We spent the first part of the year training over 1,000 DDD employees. But we do recognize that, there is a turnover rate, unfortunately, with most positions nowadays. So it's a continual process of educating people. And so you can always ask to speak to one of their supervisors if you're having any difficulty with your support coordinator on them recognizing that they have to follow this form when it's presented to them. Okay, so for the sake of this webinar, we are going to say that the person being supported's name is Jane Doe. Oh, and I got it in the edited form. I probably still have it, but that's okay. Okay, so this is a fillable form. And normally I would just fill it in there, but we're going to be going back and forth between editing the form and filling out the form. So I'm just going to leave it as it is for now. And then, so Becky, let's say the person that you're supporting, Jane Doe, let's list some disabilities here.
Yeah, so maybe say autism.
Hey, sorry, Melanie, somebody asked, can you zoom in with the screen a little bit so that we can see it a little better?
Is that better?
Yes.
Great. Perfect.
I'll be autism, ADHD, and anxiety disorder for this case. Didn't mean to mess up your boxes there.
I know, it's like doing all kinds of weird things on me right now. It's because I have it in the editing format right now, unfortunately. Okay, and then I choose, we'll just say Jane Doe's mom to be my supporter. You know what, let me see if I can stop this editing part because that's messing things up. Okay. Now give me a supporter's address. Oh, sorry, Jason.
We do have another question. It says, at what age do we start the process? Right before they are 18?
Yeah, so you wouldn't actually sign these forms until the individual turns 18, but the planning process, we say starting a planning for anything is from the date of diagnosis, honestly. But uh, through, the early stages of high school, talking about this, it's never too soon to start, but you wouldn't actually sign this document until their 18th birthday. Okay. Becky, address?
Yep. So 123 Main Street. I'll just put, yeah, USA in there. Sounds great. Great.
Break it down.
Love it.
Okay, and then phone number, we can do like a 602-555-1234.
Mhm.
And then the email address is gonna be greatsupporter@support.com. We're very inventive here. Okay. So this is where you can really kind of start to customize the agreement plan for an individual. So we did create some things here that were just like some basic items. If you wanted to stick to this, you could. You could make it more specific, more broad. This is really up to the individual being supported, how they would like these items to read. So when we're filling this out, it's under the
Melanie, we got another question. A lot of questions today. Can the Guardian use this form to have the other assistants with care of individuals who is under guardianship? Let's see if I remember that right.
Yes, so a guardian can grant permission for this form to be used. But the guardian needs to understand that they are still legally the ultimate decision maker.
And then somebody wanted to know if we will get this form that you were typing. So as an example, so we can provide that as well.
Yeah.
So,
Mhm.
yeah.
So in this specific scenario with mom being the supporter for medical, so she would not be the supporter for obtaining food, clothing, or a place to live. So you would check no. And then here is where you could get a little bit more specific. And so this is where we would edit the form. And you would say specifically based on that chart that was created, we would change this to attend doctor appointments with me.
Mhm. And then the help with filling prescriptions and managing their use from the example.
Yep.
We got another question. So the Guardian still has to sign all the documents, correct? Yeah.
So, sorry, what was the question?
It says the Guardian still has to sign all legal documents, correct? So,
Correct. Even if a guardian chooses to use this form, they would still have to sign all legal documents. Yeah, this does not remove guardianship authority or responsibility, which we have an attorney that's going to be diving into a little bit more of that later on in the presentation of what guardianship roles and responsibilities are if you did choose to go that route. Okay, so then the next section, like Becky had said, is help me with filling prescriptions and managing their use. Okay, so then we're gonna exit editing. So we're gonna say yes, yes. They're not, so mom's not filling that role of managing money because financial was gonna be uncle in that situation. So then we can go through here and click no, there's no other. Because they're going to be assisting, mom's going to be assisting with any of the medical stuff, I would recommend saying yes to having access to things that could be protected under HIPAA. And then because somebody else is going to be helping with academic, you would say no. Then the next section of an agreement says this agreement is effective when signed and will continue until. So you would only put here a date if you wanted to make this time limited. So let's say that you are a normal supporter for an individual, but you're going to be like leaving out of state for a period of time, then you could create a temporary supported decision-making agreement in that instance so that it covers the time period that you're going to be gone. So if you're going to be gone for 30 days, you would put an end date on this, and then that way you don't have to go back and like revoke the agreement.
Sorry, we got a couple more questions here.
Sure.
How does it work if the supporter dies, eventually dies? Who would help my son fill out this form again if when I pass away? So it's from Diana.
Yeah, that is a question. Actually, that's probably one of the number one phone calls that we receive at the Arc of Arizona when people are in panic. It's because the original caregiver or supporter for a person, and sometimes even guardian for an individual, passes away suddenly or unexpectedly, and there was no plan in place of who was going to take over after that happened or when that occurred. And so that is a key step in your future planning, is figuring out who would be the person that would assume that role. So you should have those plans in place prior to that event taking place.
So one more question here. Can more than one person helping in one area? So can there be more than one person helping in like financial stuff? Can you name two people? That's what I think is what the question is asking.
Yes, definitely. More than one person can help in one particular area. But this is where it's really important to define those roles. So if somebody's going to be helping out financially and one person's going to help with going to the bank and managing things at the bank, but then another person might be helping with like bill payments, this is where you could customize this form to specify those things. But if you have like two people that are assisting with that, that's fine as well. It's just each person is going to have their own separate agreement. So I hope that makes sense. So this is an agreement that I'm making between me and one other person. But if I have multiple supporters, then that means I could have, two different agreements, 3, 4. So in this scenario, we have 4 different individuals. So we would have 4 different agreements. So then the next section is going to be the decision maker's signature. So this is the person being supported. You're going to put the date that it's being signed. So today is the 12th day of June 2024. And this is going to be where Jane Doe is. Once we print this, then they would sign there. Then the name of the supporter, Jane Doe's mom, has consented to act as a supporter. So both the person being supported and the person supporting the individual would sign this document. And Jane Doe's mom's printed name, they would sign here. And this gets into that question about whether an attorney has to see this or not. Okay. So there's 2 different ways that this can be validated. It can either be witnessed by 2 separate individuals. So they would print their names here. Or you don't have to do both. Or you would, sorry, we were playing around with this form yesterday and we must have saved some things in here. You can have it notarized. So you can do either or. Do we have any questions about that?
No, it looks like we're good, so.
Okay, perfect.
We did have a question about if there's a place on the form they can mark the person as backup if they, and in the event that they pass away, so.
Yeah, you would actually just create a separate form, and on that person's form, you would put, you could put in this where you specify, like where you customize that information, you can say when this supporter is no longer available, so and so will assume the role of supporting in this way.
It also said, can a witness be a supporter or like a family or something else? Or does the witness have to be independent of the whole
Yep.
thing? Alright.
It can be anyone other than the supporter and the supportee, as long as they're 18 and they're not incapacitated themselves to the point where they have like a guardian. So they have to be able to legally sign a document. Okay, so then one of the most important parts of this form, and we get this question a lot about potential abuse and neglect, is this disclaimer at the bottom. So anyone who receives this form automatically becomes a mandatory reporter. And this disclaimer is at the bottom of every supported decision-making agreement. If a person who receives a copy of the supported decision-making agreement or who is aware of the existence of this agreement has cause to believe that the decision maker is being abused, neglected, or exploited by the supporter, the person shall report the alleged abuse neglecting system by calling Adult Protective Services, Adult Abuse Hotline, or by calling the local police department. And that is the end of the form. So once it's signed by everyone, it now becomes a legal document and must be legally recognized by anybody that you present it to within the state of Arizona.
Sorry. We do have a question about, so the form becomes effective as soon as it is signed, right?
Correct. Once it's signed by everyone. So then we would go through that process again with the cousin to go over the academic portion here. And then we would go through it again with the uncle. And then,
I think it's the wrong screen.
oh, screen is it showing? Oh, there we go. Better?
Yeah.
I have multiple screens going on right now. So like I was saying, each person, so in this scenario, you would have 4 separate supported decision-making agreements being created. And it's really recommended that this whole team come together when you're, creating this chart of supporters and really discussing all the different aspects and all the things that could potentially come up. Because if you do this ahead of time, you can see how easy it was to then transition to creating the actual document. All right, so the next portion that we're going to be going over is going to be taken over by Cyan, who is an attorney with Disability Rights Arizona, and a really good friend of mine who has helped me do a lot of different supported decision making and future planning webinars. So it's all yours, Cy.
Awesome. Hi, everyone, and thank you, Melanie. So like Melanie said, I'm a staff attorney with Disability Rights Arizona. We recently just changed our name. We were Arizona Center for Disability Law. or ACDL. And if you don't know what ACDL is or what DRAZ is, we are the Protection and Advocacy System for the state of Arizona. So we're federally mandated, and there's one of us in every state and territory. So I'm really excited to talk with you all about just a couple of different things about supported decision making. Next, please. So Melanie gave a really good and thorough update of like what supported decision making is and how it interplays with the Arizona landscape, and how it is contextualized as an alternative to guardianship. So I'm just going to give you just some kind of like key points as supported decision making fits in with the legal landscape. So I'm going to first start off with ARS 14-5303. So this occurs when a petitioner, when someone wants to be a guardian, they're going to petition the court. But before they petition the court, this individual has a duty to consider other alternatives. Why? Because guardianship is so restrictive, it essentially takes away all of an individual's rights. So the court really just wants to make sure that all other alternatives are considered. So pre 2023, because this law was passed in 2023, but pre 2023, you didn't have supported decision making. You didn't have this as like an alternative to guardianship, but now we do have this as an alternative to guardianship. So what does this mean for families who are considering all of these options? It's that they should consider supported decision making, and they must consider supported decision making before considering more restrictive alternatives. We got a question in the chat earlier about what if an individual wants an adult who is under guardianship, what if the family and the adult want to restore their rights? So restoration of rights is a tricky process, and it's highly recommended that that families who are considering this reach out to an attorney who practices in this area. But generally what happens is that you have to show that there had been a change in the individual's condition that warrants this update. So an existence of a supported decision making can show that change. So if the individual is under guardianship and they have this history of a supported decision making agreement in place with their guardian and other people who their guardian have approved, and they've shown like a decision-making skills and a history of making really good decisions, that could theoretically be introduced as evidence to show that the individual does not need a guardian. So it's so that could just be one piece. Other pieces could be a medical evaluation from someone who is very skilled in the area. So that's why it's recommended to work with specialized physicians or psychiatrists or psychologists who have that experience working with people within that area the individual has a disability in. For example, if the individual's disability is Down syndrome, you might want to talk to a psychologist or a medical provider who specializes in treating people with Down syndrome. They could provide different information or different insight as to how to build these decision-making capabilities and strengths, and provide tips on how to build that capacity. The last thing I just wanted to talk about quickly is that there is like this update to guardianship and voting rights. It is a very recent update, and I'm very excited to report this update. So previously, if a person was petitioned for a general or full guardianship, the individual automatically lost the right to vote. There was a court decision by the Arizona Court of Appeals Division 1 that states that this essentially deprived the individual individual of due process. So due process is just what is fair, what are the appropriate mechanisms to ensure that the individual can contest something. So the right to notice, the right to an evidentiary hearing. So what the Court of Appeals determined is that if a person is under or it is petitioned for general guardianship, that that there needs to be a separate evidentiary hearing to determine whether the individual has or does not have capacity to vote. And previously, the burden was on the individual with the disability to show that they do have capacity. That's no longer the case. The burden is on the petitioner to show that they do not have capacity. So that's a big win for people who are subject to guardianship and need and want to retain the right to vote. So here are our contact information. So it looks like we have a lot of good questions and we want to keep those questions flowing. Feel free to reach out to either Melanie or myself. We're always happy to take questions. So you have our contact information and you have our email addresses there. And we will open it up for additional questions if you all have any questions. I'm going to scroll through the chat. I was answering a couple questions through the chat earlier, so
There's a couple more here. It says from Australia is so I can complete these forms and have anyone witness them. It's valid. We can carry it with us. Is the so I can complete these forms and have anyone witness it, and it's valid, right? I guess is the question.
yeah, so I think Melanie touched on this. So the witnesses have to be adults and they cannot be the supporters themselves. So as long as the witnesses do have capacity, so that capacity means that they understand what the document is and what they are signing. And by signing it, they understand the legal effect of it. So as long as the individual has the capacity and they are an adult and they are not the supporter, then they can sign the agreement. And to that second part, whether you would have to take it with you or have it on you everywhere. So it depends on the context. So if you go to like a doctor's office and you want the supporter there to help ask questions, then you would have the supported decision-making agreement there with you. You might also need a release of information from the healthcare provider too. Just because there could be like exchange of medical information, and you do have federal laws that are at play. If you're like at a financial institution, then yeah, have the supported decision-making agreement there as well. It could just come into handy. It could come in handy if the validity of the agreement or arrangement is questioned. And that's why Melanie brought up the good point. The statute of the agreement is already there. So if anyone does question the validity of it, they can just look up the statute to determine that it is valid. It is Arizona law.
We have a question about how often does guardianship have to be renewed?
So guardianship, an individual who is under guardianship, the guardian themselves have to fill out an annual report. So it is due to the judge or the commissioner, and the judge or commissioner reviews these reports every year. So there is no actual renewal. It's just you have to continually fill out that annual report.
Sai, can you explain what happens if a guardian does not fill out that annual report or does not fulfill their duties?
Good question. If that judges and commissioners are sticklers for timeliness. There are cases where you can ask for exceptions or extensions. Like, for example, if your medical provider or if the individual's medical provider is not completing their portion of the form, you could ask the court for extension, but it's just generally one of those cases that you do not want to upset the judges or commissioners assigned to your case, because these forms and these reports are very important, and the court does want to make sure, and the court does want to ensure that the individual is being cared for properly, and that their healthcare is being looked at appropriately. So just make sure to not upset the court.
We got a couple questions here. Is a revocation a document that can be presented if a supporter tries to continue support using the original documents after their support has been revoked?
Yeah, we get this question a lot, and this is a great question. So, the individual who has a supported decision-making agreement, they want the supporter's rights revoked. Generally, you just need you need communication, and you need an act of revocation. So, an act of revocation could be simply tearing up the agreement, or it could just be emailing the individual, hey, I don't want you to be my supporter anymore. And you just have to communicate to the supporter that they are no longer the supporter. It's also good to follow up to the areas where the supporter had access to. So, for example, healthcare again, if the individual was a supporter in healthcare before, maybe just send a note to the physician saying, hey, Jane Doe is no longer my supporter. I just wanted to let you know I revoked the supported decision-making agreement. So active revocation, tearing up the document, or just emailing them saying that they are no longer the supporter.
All right, then I got another question here. It says, let's see which one I want to do. Is there a supported decision-making network in Arizona for families to ask questions and share information?
So you can always ask Melanie and myself questions. You can also ask organizations like the DDPC, Raising Special Kids. So Melanie and I are going to try to expand our network so that more individuals know about supported decision making and can feel comfortable answering these types of questions. Some of these questions are legal based, and so these other trainers would probably not be able to answer them, but you can always refer them over to Disability Rights Arizona, and if we can answer them, then we will definitely try to answer them.
Yeah, we do offer that ongoing support to individuals and their supporters. And if you're needing like a one-on-one session to help, create that chart of supporters, or just go over a more in-depth understanding, we're always available. And then we do conduct monthly webinars where we dive deeper into all the different support options, not just supported decision making and guardianship, but other legal forms of support that are available, and how they compare with each other. And in fact, we have a webinar tomorrow at 1 p.m. where we do a deeper dive into all of this information.
Yeah. One more question. It says, I was informed by my mom that she does the yearly update, but does not receive any document with any update date to continue approval. Is this correct? And if so, how would a parent through they have current legal guardianship?
Sure. So, so that question might be better asked to the probate court to where the individual is currently under guardianship. So, if there are questions as to like why they're not receiving paperwork or maybe the annual report, definitely reach out to the probate court in the county where the individual resides, and they can probably provide better clarification.
And somebody asked if we could provide the link for the sign up tomorrow for the webinar at 1 p.m. So we would
Sure. Grab that real quick. Or Sai, can you grab that really quick?
What real quick?
The link for tomorrow's webinar.
Oh, yeah, I can try it. I'll find that.
Okay.
I think I got through most of them. Sorry if we missed a couple. I'll try to reach back out to people that I need to answer questions. But we are coming to the end of this thing. But thank you for all the input and everything else. Do you guys have any final last words?
I am just trying to pull up right now the final thing that I know that you wanted us to include, Jason. So we just wanted to say a special thanks to the team at 88DN, which includes the Arizona Developmental Disability Planning Council, Disability Rights Arizona, the Institute for Human Development at Northern Arizona University, and the Sonoran Center for Excellence in Disabilities at the University of Arizona. And it also includes the Arizona Association of People Supporting Employment First Chapter, Employment First, and Arizona Vocational Rehabilitation. And the ARC of Arizona also is just very appreciative of being included in all of this, and we are here to support you in any way that we can. And Sai, were you able to find that?
Yep, I got it.
Perfect.
Well, thank you, everyone. And please, yeah, feel free to go to the thing tomorrow to discuss this more. So the link is in the chat there.
Thank you, everyone.